first time I've been on.
Good morning, this is Senate Judiciary, and it's Tuesday, January 16th,
Yes.
2024, and it is snowing outside, which is not a good month.
I have to keep
On
reminding
January
myself
16th,
that this is normal January weather.
yeah. So, we are taking up today S-190, a bill regarding criminal procedure and dispositions and hearsay evidence, and was introduced by our own Senator Norris and others. So, Senator Norris has kindly said Michelle should walk us through the bill.
So good morning. For the record, Michelle Childs, Office of Legislative Counsel. We're taking a look at S-190 as introduced. And as the chair mentioned, we're deviating a little bit from what we typically do, and actually we're looking at the court rules. And so those of you who have been on Senate Judiciary for a while know that occasionally we do take up court rules. The General Assembly does have the ability to amend the rules. It's usually not a starting point. So oftentimes, the legislature will bring up issues and have a conversation with the whatever rules committees, it works on these issues, and there'll be a dialogue. Sometimes the rules committee will amend them, but we do enact legislation here, amending the court rules from time to time. And so there's two rules that we're taking a look at. One is Rule 15 in the Vermont Rules of Criminal Procedure related to depositions. And then the other one is a rule of evidence, Rule 804A, that is related to hearsay statements and an amendment there. And I've given you a little packet of just some things I printed off of the court rules that I think will be helpful as we kind of start to tackle this issue. I'm going to do just a light overview of what's contained here, and I think then once you hear from some of the witnesses, we can start to kind of dig in. There's a lot of legal terms and tests, balancing tests and standards and things like that, and I think if we just kind of start with that right out of the gate, it might feel it's better maybe for you to get a little more context from the witnesses before we do that. So what I have for you and what I passed out is the first one is the full Rule 15 with regard to depositions. The next one I have for you is Rule 801, the rules of evidence, so I wanted the definition section in here so that you could look at hearsay is a pretty complicated issue. For those of you, everybody's kind of heard the term hearsay, but generally hearsay means that it is and you look at the definition here on subsection C on Rule 801, a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Now, generally hearsay is not admissible, and that is because it is not considered, because it goes to the issue of credibility. If you can't cross-examine that person and ask that person, and it's like if I'm just saying, oh, well, Phil told me this, right? And the person is not able to go and get the information directly from Phil. But there are a lot of exceptions to the hearsay rule. And so if you look at right after Rule 801, you'll see Rule 803 with some of the exceptions to the hearsay rule. Again, we're not amending these. I'm just kind of giving these for context, as I think, and they might be helpful once we start getting into discussions with the witnesses. And then the next one you have is the rule that we're amending in Section 2, which is Rule 804A, the hearsay exception. So the basis for this bill is looking at whether or not there should be exceptions with regard to depositions and also admission of hearsay evidence when you have a child victim who has suffered serious bodily injury. Right now, there are certain exceptions to both depositions and hearsay when there are children who are victims of sexual abuse and then some other offenses. And this would be extending it if the child is a victim of serious bodily injury. And I meant to print out the definition for you of serious bodily injury, but I can get that. And that's a term that we use, I think, you're probably pretty familiar with, seeing a lot of places in Title 13, as well as Title 23 and Title 18. So it is defined and used with regularity. So if you look at Section 1, so this is the amendment to the depositions.
Section 1 of the bill.
Yes.
Okay.
So it's an amendment to a subsection or subdivision of Rule 15. And so all the stuff that I have for you that's kind of sets forth the taking of depositions is in the rule that I provided for you, but we're only amending this one subdivision. So that's only what's reproduced in the bill. So you'll see, starting on line 17, deposition of minors in sexual and physical assault cases. So you'll see right now, no deposition of a victim under the age of 16 shall be taken in certain types of prosecution. So you have L&L, L&L with a child, sexual assault. You'll see the list of the various offenses there, except by agreement of the parties or after approval of the court pursuant to what's elsewhere in that subdivision. And you'll see on line 2, it's adding to that list of offenses an offense involving serious bodily injury.
Just so we can wrap our arms around it, the rule mentioned the child under 12, but this is victim under age 16.
Well, this is the deposition one. The one for hearsay is under 12.
Okay.
Michelle,
Yep.
I was wondering if, and this might be a question for Senator Norris too, but would it also make sense to include cruelty to a child as one of the offenses that falls in this?
I think, maybe after you hear from the witnesses and talk to them and see, I don't know whether or not that captures things that wouldn't already be captured here. This was something that came from the Center for Crime Victim Services that they asked Senator Norris to introduce. And so this was their policy choice of how to move forward, but no reason you can't choose to expand it if you choose.
Okay, thank you.
So just to clarify, so what Senator Sheen was focusing on is, so the way that you have under existing law, it's referencing specific statutes that are specific offenses in and of themselves. The additional language there on line 2 would apply to any crime for which the child is the victim and has suffered serious bodily injury. So it would be broader, but what I'm not sure is if they would want, in a case where there wasn't serious, maybe there was bodily injury, but there wasn't serious bodily injury, would you want to sweep in cruelty to a child? So you see, and again, there's no changes here. This is just adding to the list of exceptions to the deposition rule. But I just want to draw your attention to subdivisions B and C. So the court shall not approve a deposition unless the court finds that the testimony of the child is necessary to assist the trial, that the evidence sought is not reasonably available by any other means, and that the probative value of the testimony outweighs the potential detriment to the child of being deposed. So there's a balancing there that's going on. And I'm guessing you probably have someone from the court on the witness list, maybe, that can talk about.
Don't have anybody.
No.
We'll get Judge Zone before.
Okay.
So.
It's not necessary. I'm just saying the court can talk to you about how they weigh those things. So subdivision C, if the deposition is taken, the court is to issue a protective order to protect the deponent from emotional harm, unnecessary annoyance, embarrassment, oppression, invasion of privacy, or undue burden of expense or waste of time. And then you can see some of the things on lines 15 through the end about the conditions that the court can kind of order for looking to protect the deponent.
Mr. Chair, if I might.
Yep.
So above on page 2, line 3, it says, no deposition shall be taken except by agreement of the parties or after approval according to subparagraph B, etc.
Right.
If the parties agree, does the court still need to approve it and issue the protective order?
I don't know what the practice is. I would, for me, it's an or, but I think probably practice is probably that it's maybe somewhat of a combination, but I'm not sure.
Okay, because that would be good to know, just, because this is new to me, so.
Sure.
Maybe I can save that for one of the witnesses.
Page 3, and you'll just look at the very end of that rule. Just wanted to note, starting on line 4, is that if a deposition is taken, then the court is to appoint an attorney to represent the child for purposes of the deposition. So moving on to section 2, the amendment to 804A. And so this, Senator Sears, is related to a child 12 years of age or under, or a person with a mental illness as defined in statute, or intellectual developmental disability. And so again, this is exceptions to the hearsay rules. So if you look at the lead-in language, statements by a child 12 years of age or under, and I'm just going to focus on the child part here. At the time the statements were made are not excluded by the hearsay rule if the court specifically finds at the time they are offered that, and then there's the conditions for the court to consider whether or not an out-of-court statement made by a child under 12 years old who is a victim of one of these particular crimes can be admissible. So you'll see, starting in subdivision 1, the statements are offered, finds at the time that they are offered, that the statements are offered in a civil, criminal, or administrative proceeding in which the child is a victim, and then that's your list there of offenses, and then you'll see at the top of page 4, and you'll also note that I think the list here is broader than what is in the deposition rule. And then you'll see the addition of the language on line 3 with the offense involving serious bodily injury. It also would apply to if the statements are offered in a juvenile proceeding involving a delinquent act alleged to have been committed against a child, 13 years of age or under. Moving down to subdivision 2, the statements were not taken in preparation for a legal proceeding. Subdivision 3, the child or person with mental illness or intellectual or developmental disability is available to testify in court under Rule 807. So they could accept that out-of-court statement, a hearsay statement, but the child is available to appear in court and to testify and be cross-examined. Subdivision 4, the time, content, and circumstances of the statements provide substantial indicia of trustworthiness. Because remember, at the heart of hearsay and why hearsay generally isn't admissible is it credible, right? Is it trustworthy? Can you rely on that information?
I guess my question is, where is the burden of truth on whether it is reliable, and how does one go about proving that?
Right. I wouldn't really be the right person to respond to that, but I'm guessing that some of the witnesses would be. And then page 5, upon motion of either party in a criminal delinquency, the court shall require the child to testify for the state. The purpose of the policy behind this is to limit the number of times a child would have to be deposed or to testify in various proceedings when they're a victim of that involves serious bodily injury. There's the only changes here are expansion to the serious bodily injury offenses. Nothing with, there's already, all of the procedures are established, and I think the practitioners who work with this day in and day out can talk to you about their experiences and the advisability of it.
And so any change that this bill makes in terms of expanding the coverage would still, there would still be a court that's protecting the child's interests if it was a serious bodily injury case, in the same way that they have been with sexual assault cases.
Right, right, so it just be extended, so if that child, if it's saying, if you have a child who's been allegedly sexually assaulted, they have certain protections, this is saying, just we're gonna extend that to children who have suffered serious bodily injury.
So, just to clarify or confirm one thing here, so the change to 804A makes it so that the declarant or the person testifying who is not going to be the kid under 12, that person can bring in the out-of-court statement, right? Made by the child.
Wait, say that, I'm sorry, say that one more time.
So with this change, the person who's testifying, who could be the kid's parent,
Right.
it's saying that that parent in this hypothetical scenario could bring in
Statement that
the
the
out-of-court
child
statement
said
that the
this
child.
happened to me,
Right.
exactly. Yep.
I'm trying to understand. I'm troubled by the term mental illness in here, because I don't know what the definition in the court rule is of mental illness. I mean, it could be, you know, we're used to significant functional impairment. I don't know what the definition in the court rule is.
So the court rule refers to the statutory definition for mental illness and intellectual or developmental disability. And so I'm happy to print those out.
Yeah, would you please?
Sure.
Because I don't know how they define it.
They use your the definition created by the General Assembly. They don't have a separate definition.
Okay. I understand intellectual and developmental disability. Mental illness is extremely broad.
I assume there's also somewhere, and this is just because I have not gone to law school and poured over the law, there's probably a definition of serious bodily injury somewhere. Can we?
That's in statute. I'll print that off as
Awesome.
well.
I just want
Yep.
to take a look at it.
Sure.
Thanks.
I'm not gonna say it's simple, but pretty straightforward.
I mean, there's a lot
Yeah.
underneath this, but it is the question being asked of you is really, do you want to extend those protections to this group of children? And so I think, you know, most of your work is really just understanding what protections are there and the pros and cons of sweeping them into those protections and exclusions from the deposition and hearsay rule.
Mhm.
Okay. Any other questions? Michelle. Thank you, Michelle.
Sure.
My first witness is Jennifer Coleman. Jen on Zoom. There she is. Good morning.
Morning, Senators, and thank you so much for the opportunity to testify in S-190. For the record, my name is Jennifer Pullman. I am the Executive Director of the Vermont Center for Crime Victim Services. And I do want to thank Senator Norris for continuing to support this issue and for bringing it forward, and also Senator Sears, who, you and I have worked together on these issues for many, many years, and I know that you were a part of bringing forward many of the recommendations in a report that I'm going to speak to with respect to the 2014 VCAB report. With respect to the policy, this already has been brought up and pretty much summarized as, again, pretty straightforward, but a little bit complex. I'll never say anything's a simple bill ever again. I've learned that. But again, in terms of the policy question before you, essentially it really results in whether or not children who've been the victims of serious bodily injury are deserving of the same protections that our rules afford for children who've been sexually abused. My background, just in case it's relevant, and I think it is that I did serve as an attorney for children who'd been abused and neglected for 5 years in the Boston area. So I know what it's like to try and support them through a court process that is not a child-centered process and is extremely intimidating. I also worked with the Child Advocacy Centers for many years and also have been with the center. So I bring a background of understanding and working closely with programs and providers and children who have experienced harm and who are trying to support children who've experienced harm. Before I delve into the issues at hand, I do want to highlight the broad support we have from many entities, including some that were not able to put a letter together. That includes Legal Aid, that includes the Attorney General's Office, Voices for Vermont's Children, Kids Safe Collaborative, which is based in Chittenden County, all of the SIU, Special Investigation Unit and CAC directors. Guardian Ad Litem has issued a letter of support, who's worked in 8 counties in the Office of Child, Youth, and Family Advocate. And today you have in person representative from the State's Attorney's Office, the Victim Assistance Program, and the network. You will hear from 2 advocates today who will be sharing stories from adult victim survivors who are caretakers for children who've experienced abuse. And I want to underscore that they are not present today because they are afraid for themselves. They don't feel that they can share their own voices to tell their own stories because of fear for reprisals, fear for what could happen to them or to their children. And I appreciate the advocates who are going to be able to share that voice. So first, the why. Why are we here? The rules we currently have are predicated on a false presumption that children who've been physically abused suffer less trauma than children who've been sexually abused. From a common sense approach, that doesn't make sense on its face. For those of us who heard from the victims and survivors of St. Joseph's in Kernhattan, that doesn't make sense. We've heard about the lifelong implications to individuals who've suffered physical abuse as a child. Science also doesn't bear this out. Time and time again, there are studies that show that there's no basis for that distinction, and that in some ways, children who've experienced physical abuse are more subject to developing serious psychological disorders later on in life. Most importantly, it also sends a message to children who are survivors of serious physical abuse that they are not deserving of the same protections that our state provides to children who've been sexually abused. And I don't think that's a message that our state wants to take. When we speak to science, it got me thinking a little bit about the many conversations over the years that we've had when we think about youth who've caused harm. And that brain science that has led us to think about how we can better approach those youth, how we can better protect them from this system. And I would ask that this committee consider that brain science would suggest that we are protecting children who've experienced harm. That those protections, those considerations should apply equally. The practical matter, again, speaking of studies, I do want to reference, and this is on the committee's page, there was a report, I was a part of this panel that the governor appointed in 2014 to investigate the 2 deaths of toddlers in our state, Desiree Sheldon and Peyton Gerard. There was a 22-member panel that met for many, many months to look into these deaths. And Senator Sears, I know you're familiar with this report. It was issued again in 2014. There were many, many recommendations that came out of this report, and that report was prioritized in this committee to look at those recommendations. One of which was that special investigation units should be mandated to investigate and respond to cases of serious bodily injury of a child. And with respect to the definition, I happen to have that printed here. Serious bodily injury under 13 BSA 1021 refers to bodily injury that creates any of the following: a substantial risk of death, a substantial loss or impairment of the function of any bodily member or organ, a substantial impairment of health, or substantial disfigurement. It also includes strangulation by intentionally impeding normal breathing or circulation of the blood, by applying pressure on the throat or neck, by blocking the nose or mouth of another person. So that is our definition of serious bodily injury. And the legislature saw that that was a consensus recommendation in that 2014 report, and the legislature acted and required that all SIUs would be handling those cases, and they should only go through SIUs and should not be going through less experienced investigators and prosecutors. So what that resulted in is that we have very different sets of tools, and you're going to hear from a very experienced prosecutor and some advocates later on, very different sets of tools for those SIU prosecutors to work with cases on. You have one set of tools, which allows for Rule 15, Rule 804 protections. You have been, if the child's been the victim of sexual abuse or alleged to have been, but you have a very different set of tools and lack of protections if that child is alleged to have been the victim of serious physical abuse. And again, you'll hear how that plays out. We're talking about a very narrow set of cases. About 6 or 7 charges, to my knowledge, are coming across in our state per year with respect to serious bodily injury. And most states, in fact, do have protections that go beyond sexual abuse to protect children who've been victims of physical abuse and assault. And Senator Hashim, I know, and you had mentioned about cruelty to a child. That was a piece that when I thought, certainly, yes, I would love to have it expanded to that. But as far as a practical matter, it was important to start the conversation with relative to the serious bodily injury cases that SIUs are already required to investigate. But most states do have same protections for children who've been sexually abused as those who've been physically abused, and would not have the narrow definition that is before you, but that is tied to the SIU mandate. With respect to the rules in general, the pieces before you, sorry.
Sorry, since we're on the topic, if it's all right, I'd like to ask a question about the cruelty to a child versus serious bodily injury component. With serious bodily injury as the addition in this rule, would that also capture DUI cases or negligent operation cases? So if 2 16-year-olds were driving along, one of them was impaired, they crashed, and the passenger was injured, that passenger wouldn't be able to be deposed for that unless subsection B takes effect?
I do not believe so. That certainly wasn't the intent, but Deputy State's Attorney Diane Wheeler, who's been doing these cases for over a couple of decades, would probably be the best person as far as the expert in the room, in my opinion, on how this actually plays out in real life.
Okay, thank you. And just to add, I'm in support of this. I'm just trying to think of all the different angles. But thank you.
I just have one question.
Yes, Paul.
Jennifer, before we go any further, as long as we're on the topic of other states, do we know exactly how many other states do have these protections in place?
I have the count in another place, but I can certainly give that to you. It's the vast majority of states do have that. Last I counted, it was about 30, but I can get you the precise number.
Thank you.
Okay.
And again, I think it's important as far as how they do this, that again, it's not as tightly tied as what we're proposing. So what we're proposing is really speaking to children in terms of when you look at the definition, who've experienced the most, again, serious forms of physical abuse. And really, again, ensure that when SIUs are required to do these cases, that they have the same sets of tools and children are not left with different protections based on an arbitrary decision about who experiences more trauma.
Any other
May I
questions?
proceed?
Yeah, please do.
With respect to the amending rules and such, I've been around long enough to have been a part of the process that was in the mid-2000s when the legislature did create the protections for children who'd been alleged to be victims of sexual abuse, and encourage us to have this conversation and make change. With respect to Rule 15, do want to underscore what Attorney Childs had mentioned, that there's not an absolute bar when it comes to a deposition. There still can be an agreement. There still can be that showing, that petition to the court. And sometimes I've heard that prosecutors actually prefer to have a potential victim be deposed to see, test whether or not that victim might be a good witness. So in no case is this an absolute bar, and there can be that showing. And back in the mid-2000s, when we had this conversation around expanding 15 and 804A, there were there were challenges to that, in opposition to that, and part of that was that we're going to have a lot of hearings, there's going to be a lot of challenges, and it's going to be overturned. We're sitting here over 15 years later, and that has not happened. And Diane Wheeler will be able to speak to that, but we're over 15 years out with this process that with relative to sexual abuse cases, and none of this has happened. None of this has came to fruition. One piece that I do want to reference with respect to Rule 15 that, and you have the whole rule in front of you, I understand from Attorney Childs, is that Rule 15, Section F4, speaks to a prohibition against pro se defendants being able to question a victim in a case that's protected under E5. So pro se defendants cannot use a deposition to then question a victim of sexual assault, sexual abuse, aggravated sexual abuse. They cannot do that. That protection in Rule 15 E4 F4 does not extend to children who've been physically abused. And in this case, children who've been seriously physically abused. So you can have a situation where a pro se defendant can go and question a child in a deposition. If you were to amend Rule 15 as proposed, that prohibition would also extend to victims of those cases. I did want to highlight that. Briefly, just turn to 804A. As I mentioned, most states have expanded 804A to include physical abuse. Our expansion and definition would be narrower. But again, I will provide the exact number and list of states to the committee as soon as I have completed today. I want to mention that the intention really is to be able to bring in those non-testimonial statements, which do not impact the confrontation clause. And in fact, in Ohio versus Clark, the Supreme Court in 2015 held the introduction of a child's testimony to a teacher, a child's statement to a teacher at trial did not impact or violate the confrontation clause. That was a unanimous decision of the Supreme Court in 2015. In fact, the Supreme Court did say statements by very young children will rarely, if ever, implicate the confrontation clause because they do not understand how criminal justice and prosecution work. Furthermore, the court noted the ongoing emergency involving suspected child abuse, and that also is contributing to these statements being non-testimonial, that children are making these statements to get help from another adult, a trusted adult, or to get away from the abuse. Other states, again, have this. It's not been overturned to date, and there's no logical, rational, or legal reason, in our opinion, to not extend these same protections to this very narrow population of young children who deserve protection. Additionally,
young children. There's more than young children involved in this. It's those with developmental and intellectual disabilities and those with mental health issues. So I don't think we can, I think we need to better understand how that impacts it. It's a very much more than just young children.
There aren't any changes to those parts.
I understood, but I understand that, but it's a concern to me that we're just focusing on the kids, and I think we should be focused also on other groups who are.
I got a question for Michelle, if I might.
Yeah.
Under the 804A rule exception, Michelle, maybe you can explain. I'm not an attorney, obviously. But under the opening statement, statements made by a person who's a child 12 years of age or under with a mental illness. And if you go down to under A1, it's the 1, 2, 3, 4, 5, 6, 7, 8, 9th line down. Involving
You're on page 3?
I'm on page 1.
Oh. Page 1?
Yeah.
What line?
Oh, it's under 1, like it says, against a child 13 years of age or under.
So he's on page 1 of the Vermont statute.
Rules,
Yes.
so sorry.
I'm sorry.
Sorry.
Well, I have the benefit of being able to look over your shoulder.
You're, okay. You said you're on 803, not on
804A.
804A.
Yep.
Okay.
The first line in A, and I'm sure there's a simple explanation for this, but I guess I need to hear it.
Oh, I know what you're saying is it says 12 or under, and then it says 13.
Then it says 13.
Yeah, I don't know what that is.
Well, shouldn't we?
But that's that's the way that it is now. I can look in the notes, or we can have somebody from.
Well, let's make sure we get that right before we send anything else out.
I mean, they're talking about 12 and 13, both with mental illnesses or intellectual or developmental disability. So we got two different ages there, is all I'm asking.
Well, I took it to mean that, I don't know about the 12 and 13, that's confusing.
Yeah.
But I took it to mean any child under the age of 12, plus those who that fit the definition of mental illness, plus those that fit the definition of intellectual or developmental disability.
That's what it is for, it's 12 and under for that, but when it's a delinquency, it's the 13. What I don't know is why why there's that policy distinction.
Where is the actual 13? I'm having.
If you look under 804A, subsection A,
Okay,
subdivision 1.
got it.
Under delinquency?
Well, this is confusing.
Right.
I don't have my glasses,
Oh, okay.
that's my problem.
So
I can't find it.
the first measure, so it's like doing the test, right, to figure out whether or not it fits within the exclusion, the hearsay exclusion. And the first one is whether or not statements are offered in a civil, criminal, or administrative proceeding in which the child or the person with a mental illness or intellectual or developmental disability is a putative victim of, and then it has certain offenses, right? Then you follow that long list, and you go down, and the next thing, or the statements are offered in a juvenile proceeding under Chapter 52 of Title 33 involving a delinquent act alleged to have been committed against a child 13 years of age or under, or a person with those things. So what I'm saying is that there is that year difference about whether or not it was a delinquent act, and I can look in the notes. I'm not sure why there is that difference in that case, but that's not something you're changing. That's been a policy choice
Yeah.
that's currently in the rule that the Rules Committee established.
Go ahead.
And I can look to wrap up, because I know that Attorney Wheeler can probably answer some of these questions really well as well. So if it is okay, I can certainly just look to wrap up my comments so we can get to the experts in the room, or the experts outside of the room, I mean. With respect to the issues, some of the issues that Attorney Childs raised around hearsay and why that there are those rules, I do want to speak to the fact that, again, when we speak about serious bodily injury cases, the distinction doesn't really work with respect to when we think about sexual cases involving children, because as you all know, there's very rarely any physical evidence. Whereas when you think about the definition of serious bodily injury, there most necessarily will probably always be medical evidence. So that ability to corroborate and provide some of that extra information that we don't have in terms of what we see generally with sexual abuse cases will certainly be present. So that danger of letting in information that, or statements that might be unreliable or unfairly prejudice the defendant would not be as present in most of these cases. And then finally, just those with respect to the current landscape of what things look like in Vermont. Again, I mentioned that you all have prioritized a really important and robust response system for children who've been abused. We have an SIU and Child Advocacy Center in every single county. We are the only state, last I checked, that can say that, which means that all of these cases are going through the door of a Child Advocacy Center. They're all interviews that are being recorded, mostly through video, sometimes audio, but they're all recorded. And forensic interviewers are doing those interviews. They're not happening with a police officer. They're not even happening with, in police stations like they used to. The landscape is very different for how we respond to child sexual abuse and child physical abuse. And I just want hearing from experts in the field about what that looks like and how that impacts their work and how that impacts reforms and protections that we're trying to provide for children while also providing information to defendants. So I could certainly speak for hours on this, but I want to make sure that the folks who are here, who do this every day, have a chance to be heard. I just want to, again, stress our strong support for this work, for this legislation, and just encourage you all to think about, as a policy choice, consider the needs and protections that children of serious physical abuse deserve, making sure that we have their back as well. Thank you.
Thank you. Any other questions for Jen? Thank you, Jen. Our next witness is Diane Wheeler, Deputy State's Attorney in Franklin County.
Good morning, and thank you to the committee for listening to us and spending the time to address this issue that has been lacking in the state of Vermont. Specifically, I want to thank Mr. Chair for taking this up in such a timely manner, and Senator Norris, who has recognized the needs of the children who are victims of serious physical abuse in our state. There were a couple of questions, and before I get to those, I just want to note that in these particular statutes or rules, we are not serving at this time the most vulnerable people in our communities. Children who are victims of serious bodily injury or persons who have developmental disabilities or intellectual disabilities. These are, again, the most vulnerable persons in our community, just as the children who are victims of sexual abuse are. S-190 seeks to address those issues and to cure what is lacking in our state, and to make sure that these vulnerable persons have the same voice in our courts as any other victim. As Ms. Pullman indicated, we are talking specifically about 8 to 15 cases a year. Of that number, no more than 4 or 5 are verbal persons. That is what we have been seeing at the Northwest Unit for Special Investigations, where I have been assigned for the last 26 years, are mostly strangulation and shaking, throwing of infants and children. As I indicated, most of those matters involve nonverbal children. There's been some argument that this would clog up our court system. It is clear that with when we acknowledge and utilize Rule 804A and Rule 807, that has not clogged up the system. There has been argument that it would create a problem because we need more expert witnesses on the child's testimony. Well, those in these sex cases, that's already being done. They often utilize experts to address the forensically sound interview of the child, the interview that's been recorded either by video or by audio, which allows the experts, the defense experts, to examine what was conducted. So how this usually starts is that a child comes in, it has suffered serious bodily injury. In order to make the child safe, the child is often taken into DCF custody and assigned an attorney. That attorney is most often the public defender's office. They have that contract first. So when the defender general says, this is a problem, confrontation. What, in my view, is happening is they are not serving the best interests of some of their own clients. In practice, we do oppose, the state does oppose depositions of child victims. And under the deposition rule, we oppose it because the child, there is a recorded interview of the child. The defense has the opportunity to gather all the information from other sources, thus not necessitating a deposition. Oftentimes, the deposition is used to, in some ways, intimidate the child, which has presented some issues that the courts have addressed. We also oppose depositions of these children so that they are appointed an attorney, which is part of the rule. That attorney can address their confidentiality if they have DCF records, their privileges if they have medical or mental health records, and also confidentiality as to educational records. One of the committee asked about who has the burden of proving indicia of trustworthiness. That burden falls on the state. In order for the state to utilize that child's statement, we must demonstrate to the court that the statement has the indicia of trustworthiness. That is, we utilize how it was made, when it was made, who was present, whether the person present was asking questions. If they were they forensically sound questions? The statements that we are looking at are any statements made to the child that have an indicia of trustworthiness prior to an arraignment. So it is the point at which the accused is arraigned that any of the statements are utilized. Anything after arraignment, we cannot utilize. The theory being is that the child doesn't know what a process is, a legal process. They're asking questions, and any questions asked by the forensic interviewers are for the purposes of investigation and primarily safety for the child. I would note that under Vermont Rules of Evidence 803, which are the hearsay exceptions, if the committee look at number 24, you will see that at one point we had a rule of evidence that allowed the statements of a putative child. That has been repealed. So at one point, the legislature did acknowledge the needs of the child. But in order to narrow that down, 803.24 was repealed, and 804A and 807 were put into its place, as well as Rule 15E5, the deposition statute. Also important for the committee to know that the interviews that are done with forensic interviewers are done using a protocol from the National Children's Advocacy Center. That protocol has been peer-reviewed. It has gone through many tests as far as making sure that the questions in the protocol do get the best information, the most trustworthy information from the child. There were also questions about what that 13 means in the statute under 804A. I'm just going to go there myself. So that 13 has to do with an aggravated sexual assault. Under A1, where it says involving a delinquent act alleged to have been committed against a child 13 years of age or under, has to do with the charge of aggravated sexual assault under 13 VSA 3253. If one commits a sexual act, particularly if you're 18, 19, still under the juvenile statutes in the state of Vermont, and your victim is under the age of 13, that can be charged as an aggravated assault. Also, someone had a question about DUIs. Two 16-year-olds driving, one gets into a crash and has been drinking. The operator's been drinking. That is not, these crimes that are the very narrow crimes of, domestic abuse, aggravated assault, are not the types of crimes that would fall under that category. When someone is in a vehicle that crashes and is harmed as a result of a DUI or negligent operation, there are charges to cover that. It could be reckless endangerment, which is a misdemeanor where a deposition would not be allowed unless by agreement. There are DUI, serious bodily injury charges that could be utilized. But we would not consider it part of this particular group of statutes where we would have this 804A and 807 affecting. The cases where we have had verbal children who were victims. I'm sorry.
We have some questions. You're actually, to be totally honest with you, you're totally confusing me.
Okay, so how may I clarify?
Well, I'm gonna ask.
Hi, Diane. Michelle Childs with Legislative Council. Can I just ask a question just on the issue of, let's say, the Title 23 violations, when you're saying that it wouldn't apply in those particular cases? So if they're using that it was a if you look at the language that's in there, and it may be that the intent is for those not to apply, but I'm just wondering if the language gets at that appropriately. And so I wanted to go and explore Senator Hashim's question just a little bit more. So because it says an offense involving serious bodily injury, and I'm trying to understand why, based on that language, why if you had, some other offense where the minor did have serious bodily injury, why that wouldn't apply?
Theoretically, it could, because it's serious, if there is serious bodily injury, such as broken bones and the like.
Right.
In those particular cases, the focus of the state is on the DUI, and there's little, if any, issue with whether there's serious bodily injury. And to my knowledge, I have not done a deposition of a child who suffered serious bodily injury in over 30 years.
So you're saying in practice, you don't see that, but I think Senator Hashim's point, I think, is valid there, that if we want to get at that and you want to preclude that, then we want to think about how the language should reflect that, if it should.
It could be narrowed just as 804A and 807 are to specific crimes, domestic abuse, things of that nature. And those are and as to the cruelty to children that was also brought up, that there's a felony for those as well when there is serious bodily injury. So that could apply there too.
I just printed out a list for them of, just in a quick term search for Title 13, of the offenses where serious bodily injury is in those statutes. And so if that, just so you guys know where that came from, what I was doing there. And so if you are inclined, all I did was go onto our website and do a statute search, and it comes up with that list, and each one is a hyperlink. So if you want to click on a particular offense and see, so if you do decide from a policy perspective you want to look at saying, for purposes of this rule, if there's serious bodily injury, with these types of charges, and you want to say, we're not going to involve motor vehicle offenses, or we're not going to involve other ones, we can get at that if that's your policy.
And to be clear, what we're looking at are the cases where there is intent to harm, either recklessly or intentionally. Not those cases where harm occurs, such as in a DUI.
But you have,
Unless they're looking to, kill themselves and the juvenile in the car. So the DUIs are reckless crimes that under the intent element that we have to prove. But we're looking specifically at crimes where there is an intent to harm a child, which results in serious bodily injury.
I know what you're saying, but simple assault could be serious bodily injury, correct?
Simple assault it would be charged as an aggravated assault. When there is serious bodily injury, it is an aggravated felony case. Now, a simple assault is a misdemeanor, and while and no depositions are allowed unless it's by agreement of the party under the rule.
Abuse by unlawful restraint or unlawful confinement.
Unlawful restraint, again, they would have to have committed serious bodily injury during that restraint. That is, if they were restraining them physically, they strangled them, put them in what we call a chokehold, broke their arm, then the answer to that would be yes.
Law enforcement use of chokeholds.
They do. In the course of restraint and as they go through their ladder of response as well. But the intent is to control someone rather than intentionally harming them. What we're seeing with strangulation and chokeholds is that the person is trying to harm the child, intending to harm the person.
You're allowing, I thought the bill was rather simple. You're allowing hearsay evidence on the unlawful restraint, which might have involved serious bodily injury.
In order for this to, let me go back, I'm sorry, strike that. As Ms. Pullman indicated, this is devised to be utilized when a child suffers intentional, serious bodily injury or harm.
But the child care worker at a daycare center may not have intended serious bodily injury, but in the act of restraining the child may have caused the definition.
Well, it would have to be intent to harm. The result of that harm is whether it's going to be a matter that could have a deposition. So we have an example here from Franklin County. We did have a caretaker in a daycare, very frustrated with a child, wanted to stop the child from whining, crying, whatever the child was doing. And doing so, lifted the child up by the neck and strangled the child. That daycare provider was looking to cause some harm to the child, recklessly or intentionally, but the result of that wasn't a simple misdemeanor because the child could not breathe for a period of time. As she said, she felt like she was turning blue. That raised it to the serious bodily injury statute. So the statutes that include serious bodily injury would be aggravated assault, domestic assault, things of that nature. It does not include simple assaults the disorderly conducts by engaging in fighting behavior. It would not include any misdemeanors.
I thought this was just allowing hearsay evidence.
So the hearsay evidence would be the statements of the child. So when the child in my daycare example told their parent that the daycare worker had picked her up by her neck and she felt like she was turning blue because she couldn't breathe, that's the statement, the hearsay statement that would be allowed.
Okay. And what was the defense? What was the outcome?
Well, as happens in many cases that the special units investigate, there was a confession.
Okay.
So there was no deposition necessary. The other, in order to meet the standards of the deposition statute as it relates to sex cases at this point, what we do as policy and is we do all the depositions of any other witnesses first, because the defense has to show that they can't get the information from any other source. So the very last person to be deposed in any of the sex cases is the victim. So that we're hoping that the case resolves during that time period so that no deposition has to be done in any case. Oftentimes, because there is a confession, there's no need for a deposition. It's not a did it happen and who done it. It's what should the sentence be.
Right.
So,
and how often does it go to trial?
well, I'm about to have my first sex trial since 2020, next week.
Okay. So it's rare that you go to trial?
That is correct, because the units are so trained to get the trustworthy interview of the child and speak with the accused to get the accused to accept responsibility, because we need to get that behavior to change. So because of those two factors, the very few cases go to trial. Now, there have been, and I believe that the victim advocates, other witnesses will talk about this, there have been more cases of serious bodily injury, that is strangulation or broken bone cases of verbal children, that have not resolved short of a dismissal. And that's because of the trauma it was going to cause the child to testify. So between the sex cases and the serious bodily injury cases, my percentage of having to dismiss a case is higher with the serious bodily injury cases.
Thank you very much. So anything else you want to let us know before we move on?
Yes, Your Honor. Yes, sir. As I indicated, just to wrap up, that these are statements that have been the child has been forensically questioned by a protocol that is accepted nationally and have been defended. There have been no delay in cases and no additional experts needed. If the physical abuse is a serious bodily injury, is added to this group. Because in the sex cases, since that statute's been around since 2009, it has not caused delays. There have been very, very few cases where an expert has been called in, and that the cases have resolved as a result of the recorded statements of the child, as required by the deposition statute. So again, this is adding serious bodily injury, intent to harm or recklessly harming a child in a manner most often strangulation, and broken bones. And the most vulnerable of our group, they don't often want to testify because it's a parent or a caretaker doing it. And that has been, it's a person they love and trust, and they don't want to betray them. So we need to give them the voice in the court to tell what happened to them so that the accused may seek rehabilitation and prevent this from happening to any other child in our communities. Again, thank you very much for your time. If there are any other questions, I'm happy to answer them by email or in any other way that you deem appropriate.
Thank you so much.
Thank you.
Our next witness is Kelly Woodward, Victims Advocate from Franklin County.
Hi, good morning, and thank you for allowing me to speak. I also want to thank Senator Sears for bringing this bill forward so early in this session. And I also want to thank Senator Norris for sponsoring this bill and putting up with me nagging at him and discussing this issue with me numerous times, including in the courthouse parking lot. Your perseverance, I hope, will get this bill passed this year. For the rest of you, I am Kelly Woodward. I am the victim advocate at the Franklin County State's Attorney's Office and the Northwest Unit for Special Investigations, and I've been doing that about 30 years. Prior to starting there, I was a child abuse investigator for DCF. My caseload at the SIU is cases in which children are victims of crime, either sexual abuse or some sort of assault. I support victims at the SIU by acting as a liaison with the detectives, making sure the victim is aware of and educated about the investigative process. I provide referrals for services that victims will need. I seek victim input at decision-making junctures to make sure that the victim's voice is heard throughout the process. When a case is prosecuted, I continue that. I continue supporting the victim, educating them about the criminal justice system, making sure that their input is part of the case decision at the state's attorney's office. Sexual abuse cases right now are the bulk of my caseload at the SIU, but cases of children suffering serious bodily injury are steadily increasing and have been increasing over the last couple of years. This includes infants and toddlers who suffer abusive head trauma, who have been shaken, and strangulation of children. Those are the cases we're seeing increase. Children who suffer physical abuse are equally as traumatized as children who suffer sexual abuse. To me, they are the same children. These are the children that we serve. Protections through hearsay exceptions and limitations on depositions of children who are sexually abused were created more than 15 years ago. Those protections result in better outcomes, including treatment for offenders, safety for children, and we get those outcomes without inflicting further trauma on the child. Those same outcomes are not realized right now in physical abuse cases. Physical abuse cases are often not charged because a child can't go forward. The charge is reduced, sometimes making treatment decisions meaningless, or they're dismissed altogether to avoid inflicting further trauma on a child. Parents, therapists, or children themselves often express that the child cannot go forward. When we see that happen, when they tell us they can't go forward, it's often at the time that we need to do a deposition. Children who are both sexually abused and physically abused are interviewed at the SIU, and you heard Diane Wheeler talk about that they're trained forensic interviewers. So they are treated the exact same at the SIU. They get the same forensic interview. The interviews follow the same guidelines, regardless of the type of interview or the type of abuse that the child has suffered. The interviews are audio and video recorded and made available to the defense through discovery. And that's the process for physical abuse victims change at that point. They change at the point that a case is charged. And that's when I have to have very difficult conversations with parents and caretakers about the next step may be a deposition for your child. I want to talk specifically about a case that came to the attention of our SIU in 2015. A 4-year-old child suffered serious bodily injury during a visitation with the father. The mother brought the child to the SIU, and a forensically sound and detailed disclosure was obtained from the child. The father was charged with domestic assault, and the case proceeded in criminal court. The mom was deposed in that case and felt traumatized by the questioning that she endured during that deposition. And when it came time to schedule the deposition of her child, she couldn't do it. She just couldn't bring her child in for the deposition. She was extremely concerned about the additional trauma that the child would suffer through the deposition. The mom explained to me that to her, it felt like we were asking her to choose between protecting her child from the criminal justice system and protecting her child from the father. That case was dismissed. I spoke to that mom just recently to invite her to speak with you and to share information about her case. She was afraid to come forward because her child is still a minor and still visits the father. And she was worried that he would use her testimony against her child during those visits. She was grateful that this bill was being considered and fully believes that if her child was protected during the deposition or from the deposition, she would not be struggling 8 years later with her child's safety during visitation. She reiterated numerous times to me that she still feels that the deposition would have caused irreparable harm to her child. Another case that I want to discuss is from 2016, and it involves a 5-year-old boy who ended up in the custody of his paternal grandparents after his own parents were unable to care for him. He was physically abused by his grandfather. He was hit, slapped, punched, thrown around. His ears were twisted and pulled. There was an attempt to cut one of his ears off. His penis was twisted and punched. He was forced to take cold showers, and he was made to sleep on urine-soaked sheets. His injuries were numerous, and as you can imagine, the trauma that this child suffered was overwhelming. He was able to participate in a forensic interview, and a domestic assault charge was brought against his grandfather. However, the trauma to the child was so great that the child's therapist recommended that he not participate in a deposition, and his guardians concurred. That case ended in a plea agreement, but the charge was reduced to a misdemeanor, and the grandfather was sentenced to only a very short time on probation. And after he was released from probation, that grandfather continued to harass and bother that child for several years until stronger protections were put in place. So to me, sometimes the trauma that is caused by children who are physically abused can even be greater. It is definitely is equal and can often be greater than kids who are sexually abused. Young children who suffer serious bodily injury during an assault should be afforded the protections of this bill. The trauma that they suffer is equal to the trauma of a sexual abuse victim. They are forensically interviewed using the same rules and guidelines as sex abuse victims. They should be treated the same as far as protections in the criminal justice system. Please support this bill and pass it out of the committee and afford these children the protections they deserve. Thank you.
Thank you. Any questions? Kelly? Kelly, thank you very much for taking time with us.
Thank you.
Our next witness is Sarah Robinson from the Vermont Network Against Domestic and Sexual Violence.
Hi, good to be with you all. I think this is my first time here this session, so it's good to see you. For the record, Sarah Robinson, I'm the Deputy Director at the Vermont Network Against Domestic and Sexual Violence. And I'm going to keep my testimony relatively brief, but just to say that the network is supportive of S190 for many of the reasons that you've heard from other witnesses today. I especially want to highlight the stories that Kelly just lifted up in her testimony. We believe that this bill is a needed update to our statutes and rules regarding how the legal system responds to children who have been victims of abuse. The bill, as you've heard, extends the protections that have been in place for over 15 years for child victims of sexual violence, and those protections work well. We believe that from a policy perspective, it makes sense to ensure that equivalent protections are available for children who have experienced severe bodily injury, serious bodily injury. We know a lot more now about the impact of trauma and the impact of trauma on the brain, especially developing brains, than we used to know. And we know the impacts that child abuse and domestic violence in a home can have on children and youth. And this change will help ensure that the same age-appropriate protections are extended to children who experience serious bodily injury. While the justice system can certainly provide protections for victims of violence, we also know that involvement in the justice system can itself be traumatic. And the goal of the legal system, despite the wishes of advocates like me or others, is not necessarily the healing of victims. And so this change to include children who are victims of serious bodily injury is one step towards a more trauma-informed and developmentally appropriate legal response to child harm. So the network supports the proposal and looks forward to engaging with the committee as we move forward.
That was short.
That was short and sweet.
Any other questions for Sarah? Thank you so much, Sarah.
Thanks.
Nice to see you this year.
Likewise.
Megan Place, Victims Advocate from Windsor County. Hi, Megan.
Good morning, Senators. Thank you so much for your time, and thank you, Senator Sears, Mr. Chairperson, for prioritizing this issue historically. It's really important. I am actually sharing a letter that was written by a victim survivor, a mom of a victim survivor, who did initially want to be here and speak to you herself. But after a conversation last night, just was overwhelmed with anxiety, feeling, just scared to be vulnerable in front of strangers and to feel humiliated again, and in fear that this would be yet another fruitless process. She is, however, wanted me to express her gratitude to everyone here for considering this. And she really is just doing this for those who might find themselves in a position like this going forward, and for the children who are caught up in this process. So I will just go ahead and share her words. I'm a parent whose children have witnessed and been subjected to both abuse and violence while spending time with their own parent. I appreciate being offered a platform and space to share our experience and story today, with a hope that it will bring lasting change to the way that our state handles child victims in the criminal legal process. When children have been subjected to physical violence and abuse, the unfailing goal of the state should be to minimize the impacts on children while holding the abuser accountable. It was Christmas Day when I received a series of text messages from my 9-year-old begging me to come pick him up and his siblings from their dad's house. Hi, Mommy, please come get us right now, followed with, it's a disaster and everybody is crying. As a mother, I cannot describe the helplessness and the fear that I felt in that moment. When my children returned home to me, I came to know the trauma that they had endured on Christmas Day which led to their father being charged with domestic assault and cruelty to a child. My 7-year-old pulling up his shirt to show me the bruising on his back, tearfully recounting how his dad drank a lot of beer before shoving him into a metal bed frame and then locking him outside in the dark, leaving him alone in the snow without shoes or a shirt on. His older brother, the one who texted me later in the evening, snuck outside to give his little brother a shirt for his back and shoes for his feet. They snuck back inside the house without their dad knowing. In the days and weeks that followed, my 7-year-old sat in a hospital waiting for x-rays and spoke for hours to a DCF worker and then again to an investigator. They came to the house. We went to their offices often, requiring us to leave school daily or arrive late. In the months and eventually years that followed, they spoke reluctantly but bravely to police, DCF, school staff, and advocates. They repeated their story countless times. In fact, right up to trial prep day, my children would speak courageously to professionals and yet remain fearful to recount that Christmas day in front of their father in a courtroom. They asked me over and over again if they could just talk about it without their dad in the same room. They were worrying daily about its consequences. Negative behaviors began to emerge, enough to interrupt their school day, knowing they so desperately deserved to have their voice, but also acknowledge the stress that they were grappling with. I would go on to ask the state multiple times if there was any way they could possibly testify in another room, or if their dad could be brought in after their testimony. Is there a loophole or anything that can be done? Ultimately, I would come to hear that there were currently no provisions for children in this situation, and that they would have to testify in a courtroom with everyone, including their dad, present, and that without their testimony, the state would not be able to prevail at trial. Despite the harm and despite the trauma, in some complex relationships enmeshed with the dynamics of abuse, my children continued to love and to look up to their dad, hoping that this would never happen again. Because of this, my objective remained: my children deserve to have a healthy and safe relationship with their dad. But critical to this objective, I knew there needed to be accountability. After trial prep day, which included my 7-year-old telling the whole story over again, I went home trying to figure out whether we would be able to press forward and put the children in the courtroom with the person who hurt them, knowing the fear, the stress, the anxiety that this is already caused for them, or if we were to surrender so that they wouldn't have to be put in that position. As a mom, I knew I couldn't allow them to be put through that. If it was our only option, I couldn't knowingly allow them to be caused even more hurt. In the end, the state's hands were tied. My children were too scared to speak in court with their dad present, and the trial could not go forward. Instead, the domestic assault charge was dismissed so that the case, now consisting solely of a cruelty to a child charge, could be referred to diversion. I remember learning that case would be referred to diversion and seeing the words at the end of the email: "I am again so sorry, and I think your frustration and fear is extremely valid." I knew it was missing a "but" at the end. It should have said, "Your frustration and fear is extremely valid, but there's nothing we can do." In that moment, it felt like all we had put into showing up and talking about that day meant nothing, and I immediately felt regret for all I had the kids share, nearly promising them that it was the only way for dad to possibly get better. Diversion brought with it a whole new person for my children to repeat their story to. Feeling defeated, I mustered up the courage to bring them to the diversion office and meet with a victim's advocate in an attempt to once again address the harm, remaining hopeful for some accountability. Diversion ordered online parenting classes. However, on a visitation weekend in a public place 12 days before their father received his certificate of completion for that parenting class, he got drunk. He called the children unspeakable names, smashed their toys, belongings into pieces, and took not one, but 2 loaded firearms out in their presence. They yelled for help from strangers. My oldest son, 13 years old at the time, unarmed his father, who in turn told my son to shoot him. When a passerby stopped, their dad left on foot, leaving the children and his girlfriend until I arrived to find them all in tears and begging me to call the police. When I learned of the loaded firearm, my heart sank, knowing in a split second one wrong move could have taken my children's lives from me forever. An investigation began, and my children were once again left to tell their stories several times over. Diversion returned the initial Christmas Day case to court. So here we are again. In the back of my mind, I know the state will not be able to move forward without my children testifying in a courtroom in front of the person they desperately want to feel loved by and who also caused them pain that they cannot understand or reconcile with. The criminal legal process has left us with no other options except for innocent, traumatized, and confused children to testify against their own father while sitting in the same room as him. No custody agreement, protective order, or criminal prosecution has offered any true accountability and instead allowed for the drinking, the violence, and the instability to go on unaddressed, leading to a next time. Not only have we faced that next time, but it again involved alcohol and the added element of weapons. The blame has effectively shifted as my children have been manipulated and told by him that there are certain things they can't talk about if anybody makes them go to court. In fact, he texted me one day asking if I'm really going to do that to our children and if I'm really going to put them through something like that. He himself willing to acknowledge that testifying would be re-traumatizing and harmful, but entirely unwilling to take accountability for the trauma that he has caused them and banking on them not testifying against him. Right now, the system's only path forward for children who have experienced physical violence is for them to talk about how they were abused in front of the person who abused them. As I write to you this day, although incredibly thankful for this opportunity, I cannot help but wonder how many children have faced this reality, how many abusers have been able to walk away without accountability because we have no provisions for child victims to be able to tell their story safely and confidently in court. The only option cannot simply be that children either remain unheard in the court or be re-victimized through their testimony. Child victims must be accommodated for the criminal court without causing them more harm. This testimony is crucial to hearing evidence and vital to attaining justice for children, one of our most vulnerable and deserving populations. Experiencing and witnessing violence is well known to have psychological consequences for children, and we must not continue to add to the harm by requiring them to testify in a courtroom in front of an adult who harmed them. In 2017, the American Academy of Pediatrics issued a policy recommending and urging state chapters to advocate the state courts do whatever it is necessary within the framework of existing state laws and resources to prevent the psychological harm to the child victim witnesses as a result of participating in the judicial process. As a mother of child victims, I stand by this statement and with all who support this bill. The state has not only a moral obligation, but a duty to minimize the impact on children while holding the abuser accountable. Without accountability, there remains an inability to address the underlying issues, and it in turn prevents children from having an opportunity to have meaningful, healthy, and safe relationships with a parent who hurt them, effectively leaving the harm unaddressed. I appreciate all who are invested in this work, who have dedicated themselves to the safety and the well-being of children, and who press forward with this bill. Sharing this with you all has been incredibly difficult and scary, but I carry with me today the same level of courage that my children carried with them and having to repeat their story to strangers while hoping for some change. My children needed their voice heard when it counted, and many who abuse children going forward will need their voices heard. They deserve to be able to do this without being further harmed. That concludes her statement, and thank you all for your time today. I think she said it well enough, but appreciated.
We're just handing out an email from the Attorney General in support of S-190, adding into your file. Are there any questions for Megan? Megan, thank you so much for being with us.
Thank you all for the opportunity.
The witness is Samantha Prince, Executive Director, Windham County Special Investigative Unit, Child Advocacy Center.
Morning. I know you guys have an 11:30, so I have a lot that I want to say, but I'm going to try to condense it, and I might speak a little bit too quickly. But everything I want to say has also been provided in writing.
No, we'll certainly give you 10 to 15 minutes if you need that.
Okay. In that case, I will not go at a horse race pace. I appreciate it. So my name's Sam Prince. I am the executive director of Windham County Safe Place, which is a child advocacy center in Vermont, in the southeastern part of the state. There are 13 child advocacy centers covering the state, so every county has access to them. I know you've heard a bit about this already, but the CAC process, I attached the generalized brochure so that if you were a parent of a child that endured sexual or physical violence, you would receive a copy of that brochure or something much like it, and it would explain to you step by step what to expect. So it shows you like even a picture of the interview room, a picture of the waiting room, and it tells you who's there, who's going to greet you, how it's going to go, and what you can expect after, because the whole process is so intimidating as it stands. A lot of the information that I want to share with you is really about the prevalence of abuse, because I think it's really underrated. So children have a really difficult time providing information about being abused, and all the statistical and research information that I'm giving you is cited in that document that I shared ahead of time. So anything that you have questions about, you can find linked to the direct source. So approximately 1 in 3 kids are able to come forward to talk about their abuse right away. So it's really normal and almost expected that kids are waiting to be able to talk about things. And there's a whole litany of reasons why that happens, right? I mean, there's the obvious, there's shame, fear, guilt. Younger kids don't really have that, but they also don't know that sexual abuse is bad between the ages of like 3 to 6. They're like, maybe they have an inkling that it's weird, but they don't necessarily feel like it's something awful or gross, or that the privacy of their body has been betrayed, unlike a 10, 11, 12-year-old who knows at that point, culturally, socially, and just chronologically with their own age development. So younger kids are less likely to be able to articulate it. Older kids are less likely to want to articulate it. So the limitation on kids coming forward in the first place is already a massive problem. It's not well understood that delayed disclosure is normal, even though there's mountains of evidence on it. And so when kids come forward at the CAC, we're responsible for receiving them wherever they're at, whether they waited 5 years to talk about it or whether they waited 70 years. I spoke with a woman who was in her 70s who had never told anybody about an experience she had as a young teenager. I spoke with a young man in his 50s who had been sexually abused by his 5th grade teacher when he was in 5th grade and had only told his uncle before telling me and had never told another soul. Not telling right away is super normal. And so being able to receive kids or adults when they're coming forward and meeting them where they're at is something that's really important to us. However, in the courtroom, that looks different, right? It's just one of many things that gets held against these folks when they're talking about the abuse that they've endured. So that being said, you've heard other people say this, we use a nationally the National Child Advocacy Center, NCAC. You don't really need to remember that if you don't want to, but it's evidence-based interview modality. So that when I'm asking questions, or any forensic interviewer is asking questions, we're asking them in a way that allows the person to tell what they remember, how they remember it. So it's my job to literally just follow their lead. I'm not imposing my own feelings. I'm not offering any reactions. I'm not offering any language or any sort of encouragement. I might say, take your time, because I want to be respectful and trauma informed, but it's up to them to share with me to their comfort and their ability. And especially to their recall, because oftentimes when kids are enduring physical or sexual violence, and adults for that matter, their brains are storing that trauma in a way that makes it really hard to access in a linear fashion. So typically people can't talk about whatever the experience was from the beginning to the end sequentially without really struggling through it. And so I follow along with them as best I can, and I try to clarify and put all the pieces together until I have what feels like the totality of the information that they were able to share. And that's my job. But the detectives and the child protection workers, DCF, that are observing the interview in the other room, they have different jobs, right? They have to find out if there's criminal elements present. They have to find out if child abuse or neglect happened. And sometimes the interviewer, like myself, doesn't ask a super basic question like where it happened, because that doesn't come on my brain as understanding the experience, you know? But anyways, they get a chance to ask their questions before the interview concludes. So the child is able to be received in this super comfortable, super safe space to talk to me, who's really just curious to learn about whatever they experienced. And the folks that are responsible for figuring out if a crime or abuse happened are there listening. That way, they don't have to repeat this information. If a child also needs a medical exam, they are able to be referred to one of our specialists, because all the CACs are part of a multidisciplinary team where each of us undergoes specialized training relevant to our discipline. That includes medical providers, mental health providers, the interviewers, the cops, the prosecutors, the state's advocates, the advocate that we have in-house at the CAC, and DCF. We all undergo, whether it's didactic training or interview training, whatever. We all undergo various levels of specialized training to be able to do this work and to do it well. And so if they go to have a medical exam or evaluation and they've already been interviewed, it's our responsibility to share that information with the folks that are going to be doing the medical evaluation, and vice versa, so that we can cohesively serve these folks as best as we can. So sharing information is imperative. All of the information that is uncovered throughout this entire process eventually becomes available to both prosecution and defense, including the recordings, including the medical evaluations. And myself, I've testified many, many times about the inner workings of the CAC and what happens there and what doesn't happen, and how my role as an interviewer is different than law enforcement and DCF. So when the recording is made available for folks, we don't keep them at the CAC because we have no right to it, right? We're just providing the service of recording it, but it's on behalf of the investigating agency. So we tell people right up front, parents, kids alike, that sometimes recordings can be used in lieu of in-person testimony, but that's not a guarantee. And we ask them to consider that. Now, there are several problems and implications with the fact that sometimes kids have to testify. Sometimes it's intimidating to the point where they say, I don't want to have to testify ever. I'm not ready for that. I want to just put the brakes on this because I cannot fathom the possibility of being in a courtroom and saying what I have to say in front of this person who harmed me. I don't know if you guys have the materials that I sent you, but one of the statistics in there is that 90% of kids that are abused by someone that they know and love or trust. 60% are acquaintances. So those are people like teachers, coaches, religious folks, people that they meet at school, like supportive staff, people that they might meet in the community, youth serving organizations. 30% of the people that are abusing kids that kids know are related to them. So whether it's a parent, step-parent, grandparent, auntie, uncle, whatever. And that relation or that knowledge of that person is inherently valuable to that child. Typically, perpetrators are very kind and coercive, and when they have a sexual or physical relationship with a child in any capacity, they're doing it in a way where they're violating the child's trust and mending it or rebuilding it so that the child remains fearful. So the child still doesn't want to tell. Even at the point where the child knows they should tell, and if they tell, it might stop, there's so many layers of fear that children really still don't want to tell. And there's also the risk of losing whatever that person's role is in their life. So if that person provides financial assistance, comfort to their parent, whether they provide a service, gifts, whatever it is, they know that's going to be ripped out from underneath them. So the other issue here is that cases that make it to court have oftentimes languished for an extended period of time. I was just requested last week or the week before to testify on a case. I told you I've been in child maltreatment for 10 years this year. A good part of that was working for DCF. I've interviewed more than 1,000 kids, hundreds of adults in this time. I just got subpoenaed to testify sometime in March for a case that I worked on in 2018, where a young girl was sexually abused by her father. He conducted a whole bunch of grooming behaviors, gross stuff. I'm not going to get into it. We don't need to relive it. She now is 18 years old. She was 12, 13 at the time. And I have no idea whether or not she's going to want to testify. And because of her age now, I'm not sure if she will have to or how much bearing that will have on the proceeding of the case. That being said, imagine all this time removed, whether it's 2 years or 3 years. And even if yourself as a child or the parent of the child is feeling like you can encourage this kiddo, like you got this, you can still go do this, I believe in you. If it's been 3 years and you're now in a whole different stage of life, a whole different school, a whole different grade, you might have even moved, tried to restart things, gone to therapy, gotten help, removed yourself from the situation as best you can. Who wants to go back and relive it, right? And so there are so many ways that having this hearsay applicable to these cases for both physical and sexual violence is so pertinent to these kids healing and to the overall well-being of Vermont, because people that aren't receiving actual consequences for these things that they're doing to children are going on to become prolific offenders. They do it again and again. And I'm sure you've all seen that being part of this committee. The crimes that people commit, they commit either out of habit, out of trauma of their own, or out of interest. People that are sexually attracted to children stay sexually attracted to children. It doesn't go away. So people that are like,
I'm afraid you froze. Is there any way to contact her?
are almost 3 times as likely to be abused. And
Just
abuse
so
is
you know,
intergenerational. Say it again, I'm sorry.
Your feed froze, so we didn't hear
The last part.
the last statement.
Okay.
You froze at the idea that these people never change.
Okay. What I said after that is that kids who have disabilities or mental illness or are suffering in any capacity just behind their peers generally are almost 3 times as likely to be abused than their peers without those issues. Abuse is also intergenerational. So if these kids are born unto parents already suffered abuse themselves, they are also 3 times as likely to be abused again. So the prevalence of abuse continues to grow over time. It doesn't diminish. And the fact that kids are oftentimes born in families where abuse happened prior is another issue that can come up when it comes to providing testimony or when it comes to coming forward. There's another thing that's really important, and I'll probably wrap up after this because I really do want to be respectful of your time. There are things that are perfectly normal. And there are heaps of research behind, and everyone who works in this field knows these things, but they get thrown in the face of a victim during a court process, and it is absolutely unbearable and unfair. Medical evaluations and exams for children that have been abused oftentimes yield normal results, even if the abuse was sexual or violent in nature. By the time a child is receiving an exam, they may have healed very quickly, and there might not be anything to find. That doesn't mean that abuse didn't happen, but it's one of many things that gets thrown around in the courtroom as if to disarm and say that this did not happen. The forensic interview doesn't always capture everything. Not everybody remembers everything, and not everybody can say everything at the beginning. Disclosure is a process, not a moment in time. A lot of kids remember stuff after the fact. Some kids just want to tell about pieces of it to get it to stop. And the fact is that disclosure can come years later. I interviewed a little girl who was physically and sexually abused when she was 9, and she wasn't ready to talk about the sexual pieces of her abuse until she was 12. It's normal. Children are really likely to recant their information when they've been abused by someone that they know, love, or trust, or when that person has an important part in their life. But 92% of them are likely to reaffirm the abuse that they endured if given the opportunity. Kids don't say no. Kids don't run away. And they don't tell their parents right away. But parents all expect these things from their kids. Why didn't you just say no? Why didn't you run away? Why didn't you come get me? Why didn't you tell me? And this kind of disbelief and this kind of attitude is something that further diminishes kids' ability and willingness to talk about these things. So again, when we receive them at the Advocacy Center throughout the entire process, we offer them support. We're not lie detectors, and we're not here to tell the truth from a lie, but we are here to be supportive to these folks so that they can tell about their experiences and how they lived through them in the way that's best for them. So not only are we in support of this bill with 804A, but we ask these considerations to be extended even deeper when conversations begin with 807 and wherever else this might take us, to really consider the impact and trauma to the people that are already enduring some of the most heinous crimes and are already the most vulnerable people in our communities. Do you have any questions?
Senator Bohowski.
Yes, thank you for your testimony. So you described an evidence-based interview practice, and I'm wondering if every interviewer across the state utilizes that same method of interviewing.
Yes, yeah. So the National Child Advocacy Center forensic interview model that we use in my center is used across the state of Vermont. So anybody that's recruited to the CAC MDT, whether it's law enforcement, DCF, or a dedicated interviewer, that's what we use in Vermont. It's internationally used as well. Not every state relies on it, but it's one of, I think, 5 evidence-based modalities available in this country.
Thank you.
No problem.
Any other questions? Thank you so much for joining us this morning.
Thanks for your time.
Welcome. Michelle?
Yes.
I don't know where to go.
You can start by bringing us back to a simple bill, Michelle.
Haven't we learned that you should never, ever call it a simple bill because it's never, ever a simple bill?
Well, we've only heard one side. We need to hear from the Defender General, Judge Zone, and some of the witnesses.
Took the words right out of my mouth. It's like you read my mind. No, read my mind. Sometimes.
Is there anyone else we should hear from? Besides Judge Zone and Matt Valerio, or maybe
Might be Marshall.
Marshall.
Yeah, I think hearing from Zone A and Marshall would be good in providing context. The things, I mean, I wanted to hear your questions so that I can make sure that I can provide you with whatever information you have. I caught a couple.
Described, part of the Windham County frustration seems to be the backlog, which this bill doesn't address. But I don't know that I have questions. I just am trying to understand what the real impact would be.
Right. I think in hearing some of your questions, and just as the drafter, I think an area for exploration is the universe of cases and charges that this would apply to. And breaking it down to how it works now. And I find the rules a little difficult to read. They have a different drafting style than we do over here, and I maybe can play around with it a little bit and kind of just create, like if I was going to write it, like what it would, kind of the groups. But I think this one issue about, because you have the way that they're currently structured, which is if it applies to charges in these types of cases, right? But then you're taking or an offense involving serious bodily injury. And I felt like I was a little confused by some of the testimony saying from Ms. Wheeler about, I couldn't get what they envisioned themselves using them for, and versus like what it actually by the words on the page would be, which is why I gave you kind of a list of, and it's just anytime that term appears.
My serious bodily injury involves so many different crimes.
Right, and so something you could do is decide, what are like if the goal is that it's only going to apply, I think she said if there's like at least a reckless standard as opposed to like negligent operation of a motor vehicle. So if you wanted to kind of, you could qualify this statement
about. I'm worried that, every restraint, for example, in a residential center for troubled youth, every restraint would then become, an issue to be looked at. I'm concerned that that's one that bothered me. I think Senator Sheen's question about 2 kids, automobile accident. There was no intent to cause serious bodily injury. Shouldn't have been driving while intoxicated, but does that involve, since there was serious bodily injury in the accident, could that be charged? Those are the questions I have as to how broad are we making this. Second question I have, and I'm not opposed to where there's been abuse of the child. I mean, you look at the situation at St. Joseph's Orphanage, Kern Hatton School, we tried to deal with those a couple of years ago. And we do know that, particularly with child sexual assault, it may not be 5 years, it may be 40 years before the person comes to grips and actually confronts the abuser, or if the abuser's passed away, the organization, like St. Joseph's. So I want to know, is there any statute of limitations on this?
With regard to this, I think if you're talking about the statute of limitations is going to attach to the offense that that will be provided currently in statute. So it would be ruled by that rather than a separate.
Well, I did, with the number of statutes regarding serious bodily injury, it is a wide open field.
But I think whatever it is you decide from policy, we can craft it that way. So I think it may seem a little vague, perhaps a little overly broad for your intentions, but we can get there through the language if you'd like to move forward with the intent of the bill.
At least the witnesses we heard from was child assaults, aggravated assault is the word that was used by the victim's advocate and the Diane Wheeler, the deputy state's attorney, was aggravated assault.
Right, and I think there are like a handful that you can say if there is serious bodily injury in these types of cases, and then you could probably sweep in the vast majority of those instances that they're targeting.
So please correct me if I'm wrong, but as I'm reading the language, this wouldn't cover misdemeanor domestic assault, right? Because there's no serious bodily injury in a misdemeanor domestic.
I'd have to look at the definition because I don't remember for domestic.
I'm pretty
threatening?
sure.
Yeah, I think you're right.
Because I know there's domestic assault
Right.
and aggravated domestic assault, and I think that if we're trying to get at get the entire umbrella of abuse, we'd want to have domestic assault in there, and I think it might be worth talking about having cruelty to a child in this, because that covers neglect, willful assault, abandonment, or ill treatment in such a way that the child experiences unnecessary suffering. So, and from what I'm gathering, the focus of this again is supposed to be on abuse. So I think that's worthy of a conversation, and
does intent have anything to do with it?
I don't see that here. I know that was brought up. The witness had talked about that, but I don't see anything in the language of the rule. But I don't typically work with the rules. I don't.
Right.
So.
I'm just wondering if intent has anything to do with it.
I think what she was trying to explain was where the intent came in, was when we were looking at the many additional offenses that Michelle provided for us, and she said, well, in those particular situations, the state has to show intent. So like the two 16-year-olds driving down the road, well, if they're 16, then unless they're following this, it has to be under the age of 16, isn't it?
On the deposition piece?
Yes.
Yes, I think the issue is more that it's a person who's negligently operating a motor vehicle that results in serious bodily injury. And so I think that some of the testimony was like, well, no, this is aimed at, there's an intent to harm a child, but this language that's in here, that was the proposal from the center, I don't think gets at that. I think we can get at whatever it is that you want with the language, but I think we need to think through about, well, what are the concerns? Like you brought up domestic assault, and I'm looking at it, and it's like you recklessly cause bodily injury, or willfully cause a family member to fear imminent serious bodily injury. So when I look at this language on the bill where it says an offense involving serious bodily injury, I think that's a little vague to me, and you want to refine that, is that if you intend for domestic assault where the person fears serious bodily injury, you know what I'm saying? It's not clear because the child hasn't suffered the serious bodily injury. Is it that you have to have suffered the serious bodily injury, or these things where there's like, you use it around threats, fearing, fear around stuff like that. So I think we just need to kind of dig down and get at kind of the boundaries of what you want to put around this to get at the conduct.
And I did have one other question. The change to the depositions, that wouldn't affect civil cases? So the juvenile could still be deposed in a civil case?
I don't know how those would play together, but I can find out.
Okay. That also might be worth talking about.
Yeah, well, think of St. Joseph's
Yeah.
where there could be a civil case against the church. And we remove the statute of limitations.
I'm all about trying to go toward the intent of what they were looking for, but really need to simplify this some way or other. So this is turning out to be quite a conundrum here.
I always worry about unintended consequences. New York passed a mandatory minimum on DUI by kids. And if there was another child in the car, your example of two 16-year-olds, one brother was 18, the other was 15. And so you get charged with DUI with a child in the car and a mandatory. That wasn't their intent, I don't think,
Yeah, I think it'll be helpful to hear from the courts and the Defender General Office to sort of get a sense of what could be some of the unintended consequences.
It's interesting, though, that the backlog has to do with a lot of this frustration. I can certainly understand that. Whichever witness brought up the 2018 case, re-traumatizing the victim. Well, I don't think this is all that complex. We just need to decide how we want to limit serious bodily injury to the child abuse.
And I'm happy to work with Jennifer Pullman and the network. If Senator Hashim wants to be part of the conversation and trying to figure out how we can clarify.
All this, and I don't hear anything about the mental illness or developmentally disabled or intellectually disabled. None of the witnesses mentioned. So I think we need to get some witness.
I wonder if Vermont Center for Independent Living could speak to that.
Might or Dale.
I don't know, does it change anything regarding people with mental illness?
Would involve, while the child advocacy centers who are here don't deal with adults. There are numerous group homes for developmentally disabled and intellectually disabled people and mentally ill. And they would come under this, so perhaps who represents the mental health network? Could you find out?
Would that be Disability Rights Vermont? Would they be the sort of?
I don't know who Disability Rights would represent those individuals, but who represents the group homes? And all of those.
I think it would depend.
That group.
I think it would depend if they're state or private. If they're private, they probably have a hodgepodge of representation.
But the local mental health,
Senator, I have Commissioner Emily Hawes listed as the Commissioner for the Department of Mental Health.
Yeah, we should probably hear from her. if she has any opinion on this one. But I also wonder, in my area, it's United Counseling Service. Yours is the Howard Center.
Oh, the DAs.
Yeah,
Yeah,
that's right, designated agencies, thank you.
you're welcome.
You see if somebody represents designated agencies. If not, we just call the Howard Center and they send somebody, or zoom somebody in. If they have any concerns with it, they may not. But at least we should hear from somebody, since it does involve that. Well,
I'm happy to kind of run a little bit, so next time you take this up, some of the offenses that I think are more likely, and again, you don't have to go that direction, you can go, without, you don't have to necessarily name the particular statutes like they do in here, or you could use it by a certain standard. Jen had emailed us, right, just while we were talking about how the SIUs are mandated to investigate an incident in which a child suffers by other than accidental means serious bodily injury. So like, I think there's ways to refine it more to make sure that you're not sweeping in offenses that you don't intend to sweep in. But try hearing from some of the other witnesses, and then we can just kind of focus the scope wherever your policy lies.
And I also do want to try making sure if Senator Norris also wants to, since it's his bill, talk about including misdemeanor domestic assault, because it may not include, because that offense doesn't include serious bodily injury. So I think that's something that you're open to.
I think it's kind of taken off on the life of its own here from what the original channel we speaking to the Bergen County folks in general. We're broadening our horizons, as I always say. But that's fine.
Well, broadening and narrowing something.
Nothing narrow, nothing make it broad. Are they on right?
So.
That might be the problem.
Your biggest package is this package. You have to make.
Oh, yeah, I got it. I'll write it all out. You did. It's the evidentiary stuff is hard in and of itself,
just a
right?
reminder.
But
I'm sorry.
oh, sorry. Oh, we were just.
I just wanted to, we're ready to adjourn. We will be meeting tomorrow at 9 a.m. in the Senate Chambers. With a joint hearing of the Judiciary, Health and Welfare, and Economic Development, Housing and General Affairs Committee. And my intent is to sit in our own seats. I know it won't allow me to turn around and see who's asking questions, but you do just ask.
This is public safety. This is a spin-off of what we did with House Judiciary once again. Yeah. Getting more.
Well, it's more to what can we do about the complaints from citizens regarding the state of affairs in public safety.
So we're gonna sit back and listen to the experts on this one.
Well, we have quite the list on it.
Yeah, I see the list.
Amending the motion.